I am not going to do large and flowery introductions, even though I should and I could. Many of these scholars are far more esteemed and have been tenured far longer than I have, which is about 15 minutes. And so I am very honored and lucky to comment on their scholarship, but I could do little to completely celebrate their accolades, which I think are many. So we'll start off initially just by walking through our presentations, and we will present in the order of the program. So Professor Carolyn Shapiro will go first. Professor Craig Green will then follow, and then we'll close with Professor Ryan Scoville. And am I pronouncing your last name correctly, Ryan, just to make sure? Okay, and then I'll add a few words, even though I'm totally unqualified to do so. And then we'll hopefully open it up to any kind of comments or thoughts from the panel before turning to the audience. So just a friendly reminder for folks who've come in, you're not necessarily muted. So if you wouldn't mind just double checking your mute button, we are being recorded today. Okay. So I think, and we do have slides from each panelist. So each panelist, Carolyn, if you wanted to key up, I'll turn it over to you, and then we'll walk through our presentations before turning to our commentary and discussion. Thanks so much.
Great, thank you so much. Can folks see my screen? Great. Well, first of all, I just want to thank Andy and the other organizers. I do wish we were actually in Tucson, especially since it's about 12 degrees here in Chicago, but this is the next best thing, so thank you. The paper is obviously about something known as the Independent State Legislature Doctrine. And of course, the first question then is, what is that? And I put the word doctrine in quotes here because it's actually not really a doctrine yet, at least, but is more of a set of claims. And I want to say first where those claims come from. They come from the Elections Clause and the Electors Clause of the Constitution, which each give the state legislatures the authority in different ways to regulate federal elections. So the Elections Clause gives state legislatures the authority to regulate the time, places, and manner of holding elections. Congress can override those. And the Electors Clause says that the state shall appoint in such manner as the legislature thereof may direct the presidential electors. So that language and that grant of authority is the basis of this independent state legislature set of claims. So I'm gonna, and there are actually, I think, at least 3 that have started to evolve, and some of them have been articulated more clearly than others. The first is the claim that state constitutions cannot substantively restrict legislatures' choices when they regulate federal elections. Now, the Supreme Court has already said that state constitutional procedural lawmaking requirements do apply. So, for example, a gubernatorial veto does apply if a state constitution provides for it when a legislature is enacting such regulations. But there is dicta, at least in different cases, suggesting that the state constitutions can and cannot. And sometimes, indeed, in one case, in the same case, dicta suggesting that state constitutions can and cannot substantively restrict state legislatures' choices. This is pretty important because, for example, if state constitutions cannot substantively restrict those choices, then restrictions on, say, partisan gerrymandering and state constitutions cannot apply to congressional redistricting. The second claim is that the statutory text enacted by the legislature has some kind of independent significance, and a significant departure from the legislative scheme presents a federal constitutional question. Now, these quotes come from Chief Justice Rehnquist's concurrence in Bush versus Gore. They have been recently quoted repeatedly or referred to repeatedly in separate opinions of current Supreme Court justices in litigation related to the 2020 election. I don't this Chief Justice Rehnquist just kind of says this. He doesn't, there's not a lot of other support for it. It appears that both what he does and what the justices in the most recent round of litigation did is a kind of de novo, highly textualist review. Sort of, you might think of it as the anti-Erie. It is the claiming that, in fact, when it comes to interpreting state statutes, the state courts cannot interpret the state statutes in the way that they might ordinarily do so, and that their interpretations will not be deferred to. The third claim, which is one that I'm going to say the least about, it's also the least developed in the extent that people have talked about it, is that there's some kind of non-delegation doctrine, that there's a limit to what legislatures can delegate to other state officials, and that might include courts as well as election administrators. So let me say a little bit more about some of the justifications that folks have given for the different versions of these claims. First is obviously the constitutional text. We've already talked about that a little bit. I think it's fair to say that the constitutional text does not compel these readings. It certainly suggests that in the first instance, legislative action is required to make these, for this type of regulation, but it does not necessarily at all suggest that ordinary state constitutional and other state law other aspects of state law just do not and cannot apply. The second is history. There is, it's fair to say, some inconsistency in the history of how various different state courts and Congress have interpreted these provisions when it comes to the ability of legislatures to do things that would otherwise be unconstitutional under state constitutions. I'll just say two quick things about that. One is there's an extraordinary amount of forthcoming scholarship on this point that I think does an excellent job of making the case that the times when courts have, when legislatures have been allowed to essentially do things that would be unconstitutional are few and far between, are outliers. And for my purposes, relevantly, they are all situations in which it was extremely clear what the legislature was doing. There was no ambiguity that they were saying, we're going to do something that we know we can't do or that we might not be able to do with respect to state elections. I'm not going to focus so much on those two justifications. As I said, there's all this other great scholarship that's forthcoming. I'm going to focus on the policy justifications and the consequences surrounding them. One of the policy justifications is that the ISLD promotes political accountability. State legislatures are the most politically accountable branch. The language goes that if courts can essentially rewrite the statutes, then we don't have that kind of accountability. We've seen a lot of rhetoric like this in the 2020 cases in the separate opinions by some of the justices. A second important justification, of course, is the importance of knowing the rules and who the deciders are before an election. There are obviously concerns about predictability. There's concerns about reliance interests, which are quite important. My argument is that the most robust version, which I sometimes refer to as the maximalist ISLD, actually undermines these policy arguments in a rather significant way. And I'll just give you, before we move on, I do just want to give you an example of how the proponents on the Supreme Court of the ISLD talk about it, what state courts do, because I do think it's relevant to see the language that they use when they talk about state courts. You may recall during the 2020 election, there was a case out of Pennsylvania in which the Pennsylvania Supreme Court extended the received by deadline for absentee ballots under the circumstances of that election. Which I'm sure you all recall, was in the middle of a global pandemic, and the United States Postal Service was not necessarily going to be able to keep up with the onslaught of absentee ballots. So the Pennsylvania Supreme Court concluded that its constitutional provision that provides for, quote, free and fair elections would require them to extend the deadline. And this is what Justice Alito said about that in a separate opinion. He said, the provisions of the federal constitution conferring on state legislatures the authority to make rules governing federal elections would be meaningless if a state court could override the rules adopted by the legislature simply by claiming that a state constitutional provision gave the courts the authority to make whatever rules it thought appropriate for the conduct of a fair election. So Justice Alito is basically saying the Pennsylvania Supreme Court is arrogating to itself the legislative power, but he makes no attempt to think about what the free and fair election clause of the Pennsylvania Constitution actually means, the fact that it has decades of precedent that back it up. He does not engage with the reasoning of the Pennsylvania Supreme Court. And in fact, this interesting side note, although the Pennsylvania Supreme Court was divided about what should happen with the absentee ballots, they were unanimous that something had to change in the statutory scheme. The dissenters would have, instead of moving the received by date, would have moved the application date to make it earlier. So nobody on the Pennsylvania Supreme Court thought that the statute as written would survive under their state constitution. Now, I'm going to skip a couple of slides here, but I'm going to say I call this approach the unserious ISLD. And I see I have an embarrassing typo on my slide here. It's not the LSD, it's the ISLD. But the idea is that, right, state constitution, this is one version, state constitutions place no substantive limitations on state legislatures' regulation of federal elections. So if the absentee ballots would violate the free and fair elections clause of the Pennsylvania Constitution, that's just too bad with respect to federal elections. Therefore, so state courts cannot interpret or strike down state election laws, or in the case of Pennsylvania, exercise their equitable powers governing federal elections based on state constitutional requirements, or for that matter, they can't interpret the state election laws based on ordinary practices of state statutory interpretation. And there's one more thing, right? Federal courts, especially the Supreme Court, must police the state courts, which are arrogating this power to themselves. But what is lacking, and the reason I think this is particularly unserious, is there's no inquiry into whether the legislature intended to actually incorporate the state constitution by reference. So the idea that if a state legislature is enacting laws that would be unconstitutional with respect to state elections, and therefore cannot apply to state elections, but is enacting in many instances the same law to govern federal elections and doesn't care that it might violate the state constitution. Political accountability by itself would suggest that there has to be a clear statement principle, that the legislature must say that out very expressly, and that to think that the legislature did otherwise, that the legislature in fact is intending to have different state constitutional rules and different rules of statutory interpretation apply to these different, the same law, depending on whether it applies to a state or federal constitution, it really, I think, completely undermines the deference to the legislature that the court claims, or that the proponents claim they are supporting. Now, I'm already a little over time, so I'm going to skip way ahead and say that there are an enormous number of problems that this approach takes. It essentially federalizes state election law, because when it comes to federal elections, if a state court can't be trusted, if a state court, which is interpreting a statute in light of its own law and its own traditions and its own precedent, is not allowed to do that when it comes to federal elections, in fact, they might be worse at interpreting these statutes or reviewing these statutes than the federal courts. And so we can see ultimately there would be a dramatic heightened involvement of the federal judiciary, especially in the most fraught moments in election law. I can say a lot more about it, and I'd be happy to in the Q&A. I'll just end by saying I do think there are federal interests at stake. I don't think it is fair to say that state courts and other state officials are completely should not be ever have review of their of the decisions they make as they affect state federal elections. And the standard that I would propose is, the one stated by Justice Souter, which is, did the legislature transcend the limits of reasonable statutory interpretation to the point of supplanting the statute? In other words, an extraordinarily deferential standard that does allow for the possibility that a state court might overstep, but does not essentially engage in de novo review of statutory interpretation. And I'll stop there. Thank you.
Thank you so much. Professor Craig Green.
Thank you very much. I just wanted to say, Carolyn, I was going to say, I have this very strange thing where I have slides, but it's only going to show over my face, sort of like this. So you may want to adjust your Zoom screen or whatever for the speaker view or something like that, just in case that's useful. I just really am so grateful to be here. I've enjoyed coming to this conference every time I've come, and feel so honored and so forth. And the best way to maybe prove that is to go ahead and get right into it. But I really could go on and on. This paper, or maybe it's two papers, it has sort of two objectives. One of them is to change the image of American federalism, and the other is to study examples of American empire. It challenges what I view as a dominant constitutional geography that pervades American culture. You could see it in scholarship and casebooks. You could see it in the Supreme Court opinions. You could see it on maps you search for on Google. And this is the idea that the United States is essentially composed of states in the Union. One could fight about sort of how the states in the Union relate to one another. I've written another paper about that, sort of which came first, the chicken or the egg. This paper and project is not about that, but rather about inserting a third element of territory. And territory is definitely not a state, but it may often be on the way toward being a state. And it's definitely national, but it is also in some sense an independent legal entity and community. That's kind of the idea anyway of inserting a territory into this third mapping. This project's definition of territory is quite peculiar. It's land inside the United States, but outside of any state. And I think that intellectual architecture then supports it's a very large paper, sprawly mess in the context of trying to understand a lot of things better. But part one in the draft you have, which will eventually be, I think, Article 1, is beyond states. And it's a legal history project. Its design is to look at the constitutional skeleton. That's the kind of language I would like to use that allows states to control the United States as components of the United States. The other category I don't have such a great name for, but judicially manufactured, you can call it muscle or flab, that I think should not be deemed as constitutional. This is the kind of stuff that sometimes people think of as federalism as a substantive states' rights or this kind of a thing. I have three episodes that I think are very important, and maybe I'll talk about them along the way. The founding era, skipping a lot, but I think almost everyone believes something like the following story. At some point in the past, states were really sovereign. I mean, sovereign, I guess, like France or Spain or something. At some point, unidentified point in the past, states were really sovereign, and they sacrificed or compromised some part of that sovereignty, and then implicitly or by consensus, as a matter of constitutional under the Constitution, they now still have some of it left around in some sense. I think that basic arc or trajectory. It's something you could find in the Federalist Papers. It's something you could find from John Marshall. You could find all kinds of places. I could explain why that were true, but I think it's wildly incorrect. It's wildly incorrect. So just walking chronologically, the Declaration of Independence from Britain is a declaration of interdependence among states. It is not an announcement of state sovereignty or anything like that, nothing like that. And again, those are things that need to be substantiated, but actually the substance is very clear, I think. The Articles of Confederation is the first charter that erects the category of statehood as a legal thing in interstate law, not any other thing. And actually statehood, the contours of statehood are hotly contested, especially in concerning the location of borders, the very existence of states and the contours of them. And this is where interstate territory really makes its mark. But just to put it that way, at the end of the Articles of Confederation, once they're eventually ratified, just huge amounts of statehood remain matters for politics and not for interstate constitutional law. And this one area where they really did say something about it or imply something about it, this legal restriction that they had imposed on the government in favor of the states, they have to break it right away in order to confirm and ratify the Articles. So it is really, in some sense, an embarrassment for people who think of the Articles of Confederation as a muscular vision of constitutional law supporting some broad idea of statehood. And then, of course, by the time you get to the Constitution, the skeleton has changed, like the rules under which states represent one another and participate, that's changed. But the basic architecture is similar. And if anything, obviously not pro-state sovereignty. Nobody thinks that, although maybe in some ways. But whatever's reserved by the 10th Amendment, whatever one thinks of as state sovereignty, it's certainly no bigger than the kind of stuff that we've seen so far. And that's the support at the founding moment, this sort of entry level to the conversation of an idea of a skeleton of statehood. States are real. They are real as a matter of constitutional interstate law. But a lot of the state substantive powers and their relative status are very broadly left to the role of politics as they had been before. That has to be the lesson, I think, of this sort of first period of things, the sort of founding era, something like that. So viciously skipping sort of ahead to the Civil War. One thing to mention, of course, maybe everyone knows, is the Civil War was a fight not about slavery in the states, but primarily about slavery in the territories. And so again, emphasizing this thematic prominence of the third element. And skipping some history, but there was a war between a skeletal view of statehood and a muscular view of statehood. Lincoln and the Republicans believed that basically states, with respect to their access to territories, with respect to their control of tariffs, with respect to so-called fugitive slave laws, all of those things, you get what you get. King numbers, some of their opponents said, but you get whatever you get by the voting practices that surround the composition of Congress. And if it favors you, as far as Lincoln was concerned, maybe it will. He was pretty sure it wouldn't over time. But this idea of you get what you get, and that's all that you get, and that's all there is, and that's what the United States means, is this sort of procedural representational view of states, but not anything else. By contrast, the muscular view, of course, is Jefferson Davis and secessionists. They believe that the status as states, their constitutional stateliness, allowed them to defend their society, their economics, and their laws concerning slavery, regardless of whether they won or lost in the venue in the Coliseum of national politics. Sort of an idea of undenied and undiminished statehood. They could have cited the 10th Amendment. This is what state sovereignty means: is that when the country lurches away from you, you invoking, they of course did invoke the Declaration of Independence. You retain under the 10th Amendment or whatever else the right to say no. And if anything, I think they had at least as decent constitutional arguments as the colonists did, since they were invoking colonies created by British law. At least the southern states were invoking states that were created out of a revolutionary tradition, for goodness sake. But something like that. But the second origin of statehood, the Civil War, by this point, I think I count it, the scorekeeper, I count it as 2 points for the skeleton people and no points for the muscles. And I think that's the sort of catchphrase, if I would, sort of coming out of that. Lots and lots of history to talk about. I learned lots of things, but for presentation purposes. And then the third is this idea of there was a moment when it was possible to imagine secessionist states, that they weren't states at all. I think the panel I was on already had reference to this. Charles Sumner, state suicide, Thaddeus Stevens talking about conquered territories. Actually found a quote. I was surprised to find Salmon Chase in Oakes's book. I'm surprised to see that. And this moment I characterize in the article as really a lost opportunity and a transformative event in the trajectory of Reconstruction. So the way that we all know Reconstruction actually went was some combination of military imposition on states that existed, using the Guarantee Clause or some other set of constitutional arguments, or war powers all of which are fading arguments. There is a amendments of the Constitution, the 13th, 14th, 15th Amendments. Those amendments, projections of new forms of some forms of equality, those are all having to struggle with and stumble on ideas about statehood that are being created in that moment to resist the new assertions of federal constitutional rights, and even more importantly, federal congressional power. Of course, if those lands had been territories, the questions about federal power would be out the window, and the imposition of constitutional rights would happen in a different context than the one that actually occurred in. Now, of course, is this a counterfactual and what would have happened or whatever? Counterfactuals are hard, but at least what I would say is this gap between statehood or not, I of course think represents the conservatism, the structural conservatism of the Congress that we call radical. Charles Sumner, Thaddeus Stevens, they had ideas about what to do, and not all the ideas they had came to pass. And I think a vital tool, a legal constitutional tool, was the edifice and structure of a statehood being created in that period of time to combat new extensions of federal power in an ironic, no, it is not ironic, in a tragic way, I think is the right way to think about it. So a lot of the muscle associable with states' rights and state sovereignty does not come from any other place, but is really entrenched in this moment that from a certain point of view should have been the opposite. But this is another message about what it means to be Reconstruction and David Blight and the rest of it. I'll sort of put all that aside kind of as well. So that's kind of paper number one, if you want, or part one, I guess. In the other part is our Imperial Republic. So I did all this studying about statehood and what have you, and I found myself possessed by the folks who don't have it. And so if you had to sort of characterize the thesis points here, there are folks who are indefinitely, if not permanently, excluded from statehood. They are governed by an empire of states. No idea, for me at least, of the United States as an anti-imperial project. It's only a question of empire over whom, empire for whom. And the idea of this part of the paper was to try to support existing demands for moral, political, and legal action. Of course, it is worth stressing, maybe law professors stress it all the time, there's nothing about this that's new. This is wrestling with ideas that such problems are peripheral or incidental, which I think is a mainstream point of view in some circles that I'm trying to combat by really invading the citadel, if you want, of statehood American federalism as a central component of this. And also to emphasize maybe how invidious structural power can be coded in space. I'm very interested in legal geography, as the paper notes. And so I think this is one form. People often think of themselves as individuals having individual rights or what have you, but of course, that's something to come from this research is space also matters quite a lot, something like this. So Puerto Rico is the first. Some of you folks will know that, last Thursday, I guess the ACLU, Ayuda Legal Puerto Rico, LDF, a bunch of folks asked for explicit repudiation of the insular cases. And I think it's a very interesting sort of a moment because Puerto Rico, the space, putting aside Puerto Ricans, the group, Puerto Rico, the space, granted citizenship really quite early. There are constitutional doctrines surrounding fundamental rights and the application of fundamental constitutional rights to Puerto Rico, not so differently from the process of selective incorporation that's applied against states. I mean, there are similarities and differences there, but I think the matter of citizenship, as it's talked about, is one thing. And legal citizenship is granted. Thank you. And similarly, fundamental rights, but still imperialism, disenfranchisement persists. And I don't have anything much to add to that, but I think, again, this message that space matters, individual rights are not the only thing. And I think that's sort of important, if that's some way to think about it. Rushing forward, DC, this is a case that's distinguished in the insular cases, is Lowborough v. Blake. It's a John Marshall opinion from 1820. He says, of course, the people in DC, like the people in the incorporated territories, of course, they are within the United States. This kind of a thing. But still, DC is a vivid example of dynamics of imperial congressional rule, especially studied around the Civil War and Reconstruction. Race deeply affects DC today. These are all well-known facts. It's complicated because it's not just any statehood they're looking for. They're not looking for reversion to Maryland. They're looking for their own space and their own, the DC statehood movement is looking for something separate. And I think that ironically, there's some tricks around the 23rd Amendment, but I won't talk about them in the interest of time kind of as well. And then, of course, the last and third, I think, example of Imperial Republic, certainly by far the most complicated. So both of the others are located in a particular space in a particular time. And this actually, talk about native land, generalizing about it is immensely difficult, if not problematic. There are movements, as everyone knows, for statehood. Talk about from some of the earliest interaction in the United States with the Lenape, Delaware. There's a talk about offering statehood, never comes to anything much. There's talk about the Sequoia Constitutional Convention a great deal later, when it was possible to think about place and state and thereby incorporation into a political skeleton and structure of power. But then, of course, in the absence of that, one can see what the exclusion from the skeleton means in the context not just of dispossession and violence, but also allotment and terminations, as efforts to destroy, deconstruct elements of community and power. And McGirt was an occasion to think about it. Of course, it was a reminder that space can be something different from what some folks expect it to be. And a reminder that federal law in the system of United States law calls the shots. And so, for example, this sort of decision about the Major Crimes Act reasserts the idea that it's Congress and not the states. And that's what brings my attention to this in this project, is outside of the states, or the incorporation with states, is a matter of federal choice of law. It's still national imperial decisions that structure those decisions within that legal framework. I think that opens new and potentially important legal possibilities if it's true that the federal government within federal space can control that interaction between states and native land. Of course, the Major Crimes Act is something, but I think it doesn't take very much imagination to think that it could be a lot more, which is another way of saying if it's not a lot more, then it's because of political will and not because of legal structures that are barring it. And I think that's really where I want to conclude, is by saying that I think that in a world where territory and land outside of states are supposed to represent national values and provide a relatively low friction transmission of national values, these are the places to look to find out the disappointments on the kind of national values one might find there. Thanks very much, everybody.
Thank you so much. Professor Ryan Scope.
Thanks. Let's see. Sorry, I'm just looking for my slides. I'm not really a Zoom guy. How do you, oh, okay, got it. All right, can you, is that visible? Okay, good. Thanks. Just like everyone, I really appreciate the opportunity to share my research with you all, and I appreciate your willingness to take the time to listen. I'm also appreciative of the Arizona folks for putting this all together. I'll get right to it. So the title of my paper is The International Commitments of the 50 States. And my primary goal is to provide transparency with respect to state agreements with foreign governments. We already have some sense that these agreements exist. Everyone's familiar with sister state agreements, for example. In addition, I think pretty much everyone's heard of California's cap and trade agreement with Quebec, which was signed in 2017 and subsequently challenged 2 years later by the Trump administration. And there's been prior academic research as well. There was an important article by Duncan Hollis in 2010 that used online sources to try to get a sense for the volume and diversity of this practice. But I think that notwithstanding all of that, there's still there's still a substantial deficit in transparency. There are many questions that are unresolved. We don't know the full extent of this practice, precisely what types of issues states are addressing through these agreements, and whether any of them are problematic, whether as a constitutional matter or as a policy matter. So I wanted to try to resolve that problem. I think the problem itself actually has a number of underlying causes, though. One of these is the absence of a federal reporting requirement. There's no statute or other federal law that requires states to inform Congress or the executive branch when they enter into these agreements. Few states have systematically chosen to volunteer information on their websites or otherwise. There are no collections in private databases. If you look on Westlaw or Lexis, for example, there are no databases of US state agreements with foreign governments. And that's notwithstanding the fact that we have databases actually of US treaties, right? The US treaty series and so forth. And then, the academic research is either very old or in the case of Duncan Hollis's research, I think likely to be incomplete for the simple reason that governments themselves are not fully, transparent about the commitments that they've entered. So my first point I make in the paper is that I think that this is a bad thing. First, I think it undermines enforcement of the Constitution. That's true not only with respect to the Treaty Prohibition Clause in Article 1, Section 10, but also the Compact Clause. It's difficult for Congress to know whether it should consent or withhold consent to a compact, for example, if it doesn't know that the compact exists. Another reason why I think it's problematic is that it interferes with the ability of drafters, state officials themselves, to identify best practices. I also think it's a problem because it hinders state compliance with the commitments themselves. I came across some anecdotal evidence that even state governors' offices are not fully aware of the full extent to which their various agencies are entering into these sorts of agreements. And I think that risks a certain amount of non-compliance, if only unintentionally. And then finally, I think the lack of transparency inhibits the accountability of state officials to voters. If if voters are unaware of agreements that their representatives are entering into with foreign governments, they can't vote in favor of them in light of that performance or against them, depending on the merits of the agreements. So my goal is, again, to solve this problem by using state FOIA laws. I used, in 2020, I submitted public records requests to every major executive department and administrative agency in each of the 50 states. This was a pretty significant undertaking. There were over 650 of these requests that we sent out. And we asked in each one of them for officials to return copies of all agreements that are currently in force, whether with a national government, a subnational government such as a province or a state, or a municipal government like a city. So let me just share with you first the results. So first of all, we found that there's a very large number of these commitments. Over 600 of them were enforced, at least in 2010. This represents an 80% increase over the number that Hollis found in 2020. This represents an 80% increase over the number that Hollis found a decade earlier. So this evidence is at least consistent with the possibility that states are more active in this area than they used to be in the past. I should emphasize, though, at the same time that there are a couple of reasons to think that older agreements are underrepresented in this increase. One is that they might have been harder to access for the officials who responded to my requests, and therefore they may not have delivered them to me. Another reason is that many of these older commitments may have been terminated by the parties or expired by their terms. So although I think it's probably true that there has been an increase, I'm not sure it's quite as steep as this figure depicts. I also found that there is quite a wide diversity in terms of the volume of commitments that states are entering into. On one hand, we have California, which is far and away the leader, or at least, appears to be the leader, followed by Maryland, Texas, Washington, New York, Massachusetts, and so forth. On the other end of the spectrum, we have Wyoming, West Virginia, Kentucky. It's interesting to kind of speculate as to why we might see this variation. One possibility that stands out to me is geography. You'll notice that all of the states on the top end of the spectrum have either a border with Canada or Mexico, or a coast, or both, whereas most of the states on the bottom are sort of landlocked and have no border. These differences may give rise to different incentives to enter into cooperation with foreign governments. There's also quite a variation in terms of who the foreign parties are. The leader in 2010, when Hollis conducted his study, was Canada, but Canada has since been replaced by China, surprisingly, followed by some more less surprising suspects, Mexico, Japan, Taiwan, and so forth. This appears to be the result of primarily a concerted effort on the part of the Chinese government to engage more substantially with state and local governments in the United States. Whether that's a good thing from the United States perspective, I think is a really interesting question. On the other end of this spectrum, a number of countries did not have any reported commitments. Most of these were in Africa and the Middle East. And once again, I think it's interesting to kind of speculate as to why that might be. One possibility is that from the US perspective, there are fewer economic opportunities and thus fewer incentives to pursue economic, sort of cooperation through these agreements. There might also be a political disincentive. You'll notice that many of these countries are countries with which the United States does not have particularly strong relations, and that might operate as something of a discouragement to further cooperation. I also broke the commitments into three categories in terms of whether the foreign party was a national government, or a subnational government in the form of a prefecture, state, or province, or a municipal government or a city. I designated state commitments with the first set of foreign governments as upward, in the sense that a national sovereign is sort of above a US state in terms of its political status. The prefectural and provincial agreements with US states are horizontal in the sense that they're sort of just analogous to US states as actors. And then the downward commitments were those with cities and municipalities. I think it's interesting that almost half are with national sovereigns, right? The Chinese national government is entering into these legal agreements with the United States, the government of France, and so forth. That raises, I think, or sort of accentuates the importance of the question as to whether this is consistent with US national interests and what the interests of the federal government in particular might be in regulating this practice. In terms of the principal topics of commitment by volume, they also varied considerably. The most common was what I designated as sort of general. These were general either because their scope was so broad as to sort of preclude the possibility of coding them as falling into one specific policy category, or because they were just too vague. Many sister state agreements, for example, fell into this category. After that, we had trade and investment as the most common topic, followed by natural resources, transportation, education, insurance, tourism, agriculture, and so forth. There were some topics that were actually pretty surprising to me, some on cybersecurity. There were a few on military-industrial cooperation, some on the protection of archaeological sites, really just an incredibly wide variety of topics. One of the major reasons I pursued the project is I wanted to evaluate the constitutionality of these commitments. And that's true not only with reference to the Treaty Prohibition Clause of Article 1, Section 10, but also the Compact Clause. So what I did next was to try to code the commitments based on whether they exhibited the indicia of treaties under the domestic law pertaining to the Treaty Prohibition Clause. That's a little bit of a challenge because the Supreme Court has never, at least a majority of the Supreme Court, has never embraced a particular definition of treaty for purposes of this clause. But there have been a number of possibilities that have been sort of thrown around. One of them is an originalist approach, which focuses on a definition from Emeric Vattel, an 18th century international lawyer. Another is a definition that was used by Justice Taney in a case called Holmes versus Jennison. A third definition was one used by Justice Story. I won't get into too many of the details on the coding here, but suffice it to say that depending on which of these definitions you use, the portion of the commitments that seem potentially problematic under the treaty clause expands or contracts. Under Vattel's definition, the sort of originalist approach, for example, up to nearly a quarter of the commitments would seem to qualify as treaties and thus unconstitutional if you were to take an originalist approach. I also looked at whether they were agreements or compacts for purposes of the Compacts Clause, and in particular, whether they are agreements or compacts that require congressional consent. As many of you know, the Supreme Court has interpreted the Compact Clause not according to its plain language, and instead as requiring congressional consent only where an agreement or compact threatens federal supremacy. And so I went through the commitments. I looked for the various criteria that the Supreme Court has identified as indicative of an agreement or compact. And I also looked at whether the commitments in question pose any plausible threat to federal supremacy. I'll just identify a few of these that I think fit that description. So first, roughly 1/4 of the commitments appear to be binding. They don't have any disclaimers with respect to whether they are binding, and they contain the language of obligation. I think it's quite plausible that these pose a threat to federal supremacy, given that we have federal supremacy over the conduct of foreign relations, and given that these commitments are, in many cases, not only with foreign governments, but foreign sovereigns. There's a real potential challenge there to federal supremacy with respect to the conduct of foreign relations. More specifically, and this was, I think, one of the most surprising findings, I found a collection of commitments with the Chinese government, not only the national government, but also subnational governments, that were for the express purpose of promoting technology transfer in a number of strategically fields of innovation like nanotechnology, semiconductors, biotech, information technology, and so forth. Here as well, I think there's a plausible argument of a threat to federal supremacy. As you know, that the Committee on Foreign Investment in the United States has been set up for the express purpose of trying to protect US technological leadership in these sorts of areas. And yet these commitments seem to push in precisely the opposite direction. I found a 2005 MOU promoting economic cooperation between Idaho and Xinjiang province, which seems to be, operating in some tension with recent efforts by the Biden administration and Congress to hold China accountable for the genocide of Uyghur Muslims. There's a 2017 MOU between Mississippi and Cuba that expresses a pledge to improve business activities between them, notwithstanding the federal embargo. A 2019 MOU between Mississippi and the Israeli Ministry of Defense that obligates Mississippi to introduce defense technologies to the Israeli ministry. That seems like a potential threat to federal supremacy with respect to arms exports. So these raise, I think, at the very least, interesting policy questions that officials should consider in addition to constitutional questions. So just the rest of the paper, just to close very briefly, asks the question of what can be done to improve state practice in this area. And so I identify a number of drafting techniques or drafting reforms that state officials could adopt, including, for example, stating outright that they don't intend their commitment to qualify as a treaty for purposes of Article 1, Section 10. I think that's pretty low-hanging fruit that wouldn't require very much. I also think that Congress could enact something analogous to the Cases of Blocky Act, requiring states to report their commitments to Congress or to the executive branch or both. And then I think that there are state level reforms as well. There's legislation in California and North Carolina already that requires a degree of transparency with respect to these commitments. Other states could very easily, I think, replicate those reforms without too much administrative cost or other problem. So I'll close there. Thanks.
Thank you so much. I'm going to offer some comments in the reverse order of presentation before opening it up for response from the panel, and then hopefully your questions. I'm sure there are many at this stage, given the richness of the paper. So I'll begin. So in the international commitments of the 50 states, Professor Scoville continues his tour de force through an area of scholarship that could be termed diplomacy in unexpected places, moving from diplomacy engaged in not by the president, but the Congress in his earlier work on legislative diplomacy. Scoville now focuses his attention down the vertical separation of powers onto the states. And there, through his own impressive FOIA gathering, he's amassed an original data set of agreements between states and foreign parties, both national, subnational, and with municipalities as well, surprisingly. This current draft draws on that original data set and contributes much to our understanding of the dynamic nature of constitutional law in the context of foreign affairs. Most notably, it reminds us that the constitutional project is not simply one of the Supreme Court, nor is it simply that of the three branches or departments of the federal government, but that it also implicates state governments and state action also, and not simply in defining the Federalist framework. States are actors in making constitutional meaning, even in the domain of foreign affairs. The draft also helps us to supplement what Professor Bridget Fahey has called, quote, our impoverished vocabulary for intergovernmental agreement making. Not only have the states begun in earnest to contract with their own governments, with the federal government and with tribal governments, they've now reached again beyond their territorial borders to create agreements of various kinds with other foreign powers, agreements that implicate areas of our Constitution that are rarely studied and are litigated even less frequently. The draft is so rich in its implications that it left me puzzling over a few broad areas. So first, I wondered why there were so few meaningful local agreements within states and between states in order to govern a myriad. Fahey documents over 200 agreements between states, and these agreements focus on very different subject matter: law enforcement, immigration, infrastructure, the meat and potatoes of day-to-day governance over borders. So why are there such fewer agreements with foreign governments, especially those governments with which states share a border? And why is there an increase in the past 30 years, beginning around 1980, but really taking off around 2013? Is this yet another story of congressional dysfunction and the states taking the same initiative that the other branches are taking in its absence? Or does it follow from the broader history of government compacting, like the one Fahey describes? Second, I wonder about the relevance of history to a deeper understanding of these data, and not just the history of intergovernmental compacting for the last 50 years, but that of the long 19th century and the founding. This history could not only provide more context for constitutional questions surrounding treaty and compacting limitations on state governments, but it could also provide a possible explanation for why the practice of compacting with foreign governments is distinct from that of compacting within the Federalist framework. To provide an example from early American history, the relationship between the states and federal government to foreign powers, especially native nations, was in heavy dispute before the drafting of the Constitution. The Articles of Confederation created such a metal that the federal officials had to arm themselves at treaty negotiations to prevent state officials from disrupting those negotiations, both governments hungry for native land. Many of the limitations on state treaty and compact making imposed by the Constitution aimed to resolve this dispute and to stabilize the Union. And so lastly, I was wondering about the payoff of the paper. The lack of meat and potato style governance agreements dealing with local issues left me wondering about the significance of these agreements. Why are there even so many? Is it possible to further separate meaningful agreements from those that operate as simple political signaling? Or is it possible that I'm asking the question of significance about the wrong body of law, that is not domestic, but international, an area that I'm less familiar with? And perhaps are there other diplomatic questions to which the agreements give rise beyond their constitutionality that the paper could address? So for example, the overstated role of Quebecois agreements in the paper had me wondering about the implication of these agreements for recognition and their relationship to subnational governments seeking secession or a grander position on the international stage. So is this paper primarily one of domestic law or federalism paper? Is it an international law paper that really presses on Federalism 2.0 scholarship to push it on to more of the international scholarly conversations or not? So a bit of clarification in that would be helpful. So turning next, so the contributions of our Imperial Republic by Professor Craig Green are many and largely sound in the field of legal history. To provide just a few examples, the draft joins a burgeoning literature on the flexible and contingent nature of the Federalist framework at the founding. Rather than presuming our father's federalism, Professor Green reveals its origins in the contested and overlapping sovereignties of 18th century North America. So like those I just referenced with respect to the last paper, the draft also reminds us of a lost alternative history of Reconstruction, where the federal government considered and rejected the possibility of rendering the secessionist southern states as territories, destroying their state status. But most importantly, our Imperial Republic offers a longue durée view on the influence of the American colonial project on the shape and formation of the constitutional power of the national government over jurisdictions delineated as territories. Too often, historians of American imperialism begin their histories at the end of the 19th century, after the frontier, infamously described by Frederick Jackson Turner as the, quote, meeting point between savagery and civilization, was closed. Trained as an early Americanist, Professor Green reaches back to the period before the Articles of Confederation and the dispute between Maryland and Virginia over the lands that became the Northwest Territory, lands notably held by Native people and in heavy demand from speculators, the founding fathers among them. From this longue durée history, Professor Green argues for a centering of territories in the study of constitutional history, even going so far as to equate reserved lands held by Native nations pursuant to treaty law as territories. This argument gives rise to several questions, not least among them is whether the legal category of territories does the work that's necessary to capture and convey the issues of American colonialism within our constitutional history, or does offering territories as a central organizing frame of study risk at best misleading future analysis, or at worst return us to an era where the central issues are obfuscated by the frame of analysis applied. I'm going to offer a suggested answer to these questions drawn from the field of history. So for generations, Civil War and Reconstruction historians were stuck in the frame of centering and blaming government structure, that is federalism and states' rights, for the fissures in the Republic and the bloodiest domestic war in United States history. It's only recently, due to the relentless fight of Eric Foner and others, that the field began to face the reality that to understand the Civil War, one must center and study the institution of human enslavement. Government structure was largely neutral and could be seized and shaped toward all sorts of purposes. Here, federalism and states' rights were turned towards the enslavement of human beings for profit. And it was that morally abhorrent goal that we must study to understand the dynamics of American history. The worry is that centering territories repeats these shortcomings to the letter. For example, on page 15, the manuscript argues that, quote, federal power over territorial governments almost destroyed the Union, rather than the institution of slavery itself and the structure of political economy behind preserving that institution. But the manuscript also bears tensions that reveal its discomfort with this argument. See, for example, the balance of the section arguing not that territories, but territorial slavery almost destroyed the Union. To provide another example where the manuscript centers state power and federalism within its causal argument, on page 29, it gestures to an alternative future for Reconstruction if only the United States had imposed territorial status and governance on the rebel states rather than preserving states' rights. But again, the manuscript reveals discomfort with its own central argument. So see then page 57, where, quote, territories have been channels for legal and illegal violence. They have unsettled lands and society much more often than the other way around. So I offer today the same suggestion that I've offered elsewhere. Not only must scholars center the institution of slavery, but we must also center American colonialism and the Native people subordinated by that project in order to understand United States constitutional history. Centering American colonialism and Native people reveals the vital and contingent ways that constitutional law and structures of governance, territories among them, were shaped by and toward the American colonial project. Centering territories as a form of government structure could fall into the same misleading frame of analysis that trapped the study of the Civil War and Reconstruction for generations. And so rather than offering another trap, this draft promises to make an impressive contribution as an argument for the centrality of Native people and American colonialism to the development of the territorial power and the form of territorial governance within the United States, should it choose to center the morally abhorrent goal rather than the tools of government shaped to achieve it. So finally, we have Taking the Independent State Legislature Doctrine Seriously by Professor Carolyn Shapiro. With this draft, Professor Shapiro offers a marvelous doctrinal history and deep dive into the current and future issues surrounding the emergence and resurgence of the so-called independent state legislature doctrine, and particularly the maximalist version articulated recently in the context of challenges to the 2020 election. Professor Shapiro documents well the contours of the doctrine, so I won't revisit those intricacies here. But what particularly caught my attention was her description of the ways that the Supreme Court's overly simple legal process model of lawmaking and legislatures could be influencing not only the horizontal separation of powers, but our federalism doctrines as well. More specifically, the draft details how the justices articulating the maximalist independent state legislature doctrine are envisioning state legislatures in the simplest terms, often treating the lawmaking process as entirely abstract, consisting only of legal text created within a vacuum. Taking the justices at their word, they believe that state lawmakers are not reflecting on constitutional limitations or the statutory landscape already enacted when crafting and passing legislation. The statutory landscape within the states often includes principles of interpretation specifically mandated by state legislatures or developed in great detail within the states as, quote, laboratories of statutory interpretation, as Abby Gluck has termed them. The draft categorizes a range of risks to state and federal law that could arise from this doctrine, but I wondered whether the draft might have space to explore some possible broader explanations, beyond the unstated presumption that the justices are acting in a partisan or political manner for the justices' sophomoric approach to state legislatures. Explanations that might lead to connections with scholarly conversations about the court's relationship to the Congress, and ones that might offer more structurally focused reforms. The first question I had was whether legal process theory and its vestiges might be playing a greater role here. As Professor Abby Gluck and others like myself had noted, many of the justices were trained in a pedagogy steeped in legal process theory. That is a vision of lawmaking that models each branch with a function and views that function in simple, abstract terms. Even beyond oversimplification, legal process theory provides a dated view of legislatures and one that's far too rooted in the federal system. Scholars have noted that this short-sighted vision of legislatures has undermined the court's approach to statutory interpretation and review of statutes at the congressional level. So these areas of scholarship might be helpful to bring into conversation, and to especially to identify ways that our federalism and election law doctrines have been undermined similarly. This is a broader story across many levels. My second question builds on the first, and asking whether efforts to rein in the Supreme Court with respect to Congress by offering a more nuanced vision of legislatures is an effort that needs to incorporate state legislatures also. And Professor Richard Burfault has written on this, and he's in the room also, maybe can speak to this later. But not only do state legislatures operate as Professor Shapiro notes in her draft, to interpret the constitutionality of their own proposed bills and to draft legislation against the statutory and common law landscape. State legislatures are even more distinctive from the Congress in that they are more assertive in the statutory interpretation process and even less deferential to the courts. Further, as the draft notes in footnote 126, state legislatures are possibly even less so bastions of democratic legitimacy than the Congress. Drawing on recent work by Professor Miriam Siefter, where she describes the quote counter-majoritarian legislatures in states as often the least democratic branch. As she notes, state legislatures are often captured by a state's minority party through gerrymandering and other creative electoral rules. And it's the executive branch governors and state court judges that are more often chosen by the democratic majority of the people through statewide elections. So these are all incredibly rich projects, and I could just keep talking all day, but I'll stop there and see if our panelists would like to respond before opening the conversation to our audience. And
Yep.
yeah, please, if you'd like to go first, Ryan.
I'll just make one. I'm more interested in hearing what other people have to say, but I'll just make one response, which is that I really like your question about the history of these commitments in particular, because it's something that I think is underexplored. I frankly don't know why they became or appear to have become more common when they did a few decades ago. There are a few possibilities that seem plausible to me, but I certainly have not done the research from sort of a historical angle, and I'm not really aware of any other research that has either. So it would be an interesting future project. It'd be great to see the results of. But thanks for your comments.
I'm similarly super grateful, obviously, to the attention and the care. And of course, all these things that you've mentioned are things that I need to be very careful about. I wanted to just say two quick things. One of them is about the Civil War. And it's interesting to me that, of course, I approach with that same historical background, thinking about, as most people do, the inhumanity of slavery and the economics of slavery. And one interesting thing is that, of course, Jefferson Davis and Abraham Lincoln and the Republican Party and the Democratic Party don't experience it quite that same way. They have a numbness, if you want, or a certain kind of a toleration for that basic inhumanity of slavery, and are, of course, enormously complicit with the economics you described. And so one of the things that was interesting to me, and the voice that I liked a lot, that I was happy to find, was Frederick Douglass, who speaks about the federalism aspect. And this, I try to sort of anachronistically project that conversation to the bones of federalism that he thinks need to really be interred and never actually end up being that way. But I think that I think I need to be much better and clearer about on that point of territory as a vehicle for having these sort of disputes. And I think on the latter point, I think I think I just have a lot more work to do. Of course, the last part, the second paper, Our Imperial Republic, is way too short. So, for example, there isn't not only, of course, for Native voices, but of course there are very few Puerto Rican voices, and even African American leaders in DC don't have enough actual presence in the story. And so, one of the impetuses for splitting in half, I think, is the hope of finding some way to do a better job at that. And so, I just really wanted to say that I think that's awfully important. And I may be impetuous enough to reach out and try and find solutions, but even if not, I think it's exactly the right course.
Well, thanks from me as well for the comments. There's so much I could say about your comments. I'll just I'll say there's a really, to me, a very interesting kind of meta investigation that I think some of what you've suggested goes to and is beyond the scope, I think, of this paper, which I do want to keep kind of focused on the doctrine and the consequences of it, because for a variety of reasons. But there is, I think, a big meta conversation to be had about the way that the court talks about legislation and legislatures, both Congress and state legislatures, and the rhetoric it uses in different contexts to attribute political accountability or political corruption, depending on the specific, or maybe corruption might be too broad a word, capture, and to sort of map that onto the the different types of decisions that the court is, the subject matter or the types of decisions or the implications of the decisions that the court is reaching. And I think your legal process point really points very much to that. Actually, both of your points do. So I'll just leave it there because I also want to hear what other people have to say.
Thank you so much. And we have only about 10 minutes left for questions, but we have a whole 10 minutes left for questions. And so if you'd like to put a cue into the chat, that is our cue. And then once I call on you, you can unmute. Please feel free to queue up even if someone else is speaking. So first we have Catherine Mims-Crocker.
Hey, thank you all so much. Your papers are totally fascinating. My question is for Ryan. Ryan, it's nice to meet you over Zoom. You know that I'm interested in interstate compacts, Ryan, and the compact clause itself applies not only to state foreign compacts, but also interstate compacts. And so I'm just wondering, you know, what, if any, implications you see for interstate compacts from the work that you've been doing here?
Well, interestingly, one of the implications is something that you are yourself very much interested in, which is the possibility that we can address problems concerning foreign compacts through federal legislative reform. One of the reforms that I discuss is the possibility that the possibility of a legislative reform that would essentially say that once a state reports a commitment to Congress, subsequent inaction on the receipt of that commitment should be deemed as sort of implied consent. I'm skeptical of the value of that sort of reform, at least in the context of foreign compacts, given some of the unique risks that they seem to pose, but I'm more open to the possibility of it with respect to interstate compacts. You know, one of the other interesting issues here is the question of what standard should govern the constitutionality of foreign compacts as opposed to interstate compacts. There's this ongoing debate about whether the standard should be more stringent when it comes to foreign compacts. I'm not actually sure that I'm persuaded by that argument, but you know, it's something that has not yet quite been resolved, I suppose.
Travis Crum.
Thanks to all the panelists and to Maggie for just a really great presentation and discussion here. Since we're supposed to only ask one question, it was really hard to pick, but I'll ask Caroline as an election law scholar. One of the things I kind of noticed in the paper is when you're sort of framing the discussion about delegation, you're mostly doing it vis-a-vis horizontal delegation within state government. So how much power can a state legislature give to a state executive branch? And some of this discussion is coming out of the fact patterns of the 2020 election. But as we saw in 2000, and as we also saw in 2020, but they weren't the kind of hot button issues, how county level and city level administrators are interpreting state law also raises some really difficult questions. And I would suggest as you're kind of expanding on the paper, raising those types of questions, because they do come up a fair amount, and how much authority under state constitutions do state legislatures or attorney generals or secretaries of states have over county officials is contestable. And one source to point you to is that in the South Carolina pre-clearance trial, one of the last pre-clearance trials that happened over their voter ID law, there was a real debate about whether or not the Attorney General of South Carolina could order county officials to do things. Because the state constitution and state law gave those county officials a lot of authority. And so that might be one rabbit hole to go down as you try and problematize this kind of federalism all the way down aspect to the independent state legislature doctrine. But really great paper. I'm really glad to see it out there in the world.
I'm just going to say thank you. And I do have some thoughts about that. But I don't want to delve too deeply into the minutia of state election administration, which I have learned a lot about in recent months. I may want to talk to you offline if that's okay.
Okay, next we have Richard Burfault, and we may have time for more folks in the queue if you have pressing questions.
Thank you. Thank you for all the papers. I learned a lot from all of them, but like Travis, I'm going to focus on the independent state legislature doctrine. Just some mixture of observations and questions. One is, maybe it's too current to think about, but whether you might want to tie this into the ongoing debates over the Electoral Count Act, which is also more about the role of Congress, but also I think deciding who is going to speak for the state. If the thrust of congressional reform, if it ever happens, is about limiting Congress's role and deferring to the state, who is speaking for the state, or who does Congress think is speaking for the state, and so it takes on, it's more of a side issue, but maybe not so side. And it kind of relatedly is whether you think this would or should, or the arguments play out differently for the electors and the elections. You're absolutely right. It's two different articles. Article 1 gives Congress the power to preempt state regulation. Article 2 does not. I also wonder about the difference between the language of such rules and regulations in Article 1 and manner of election. I believe there is some argument by some legislators that if they decide to elect or select the electors, they don't need the governor because it wouldn't be through legislation. I think the assumption, I haven't had a chance to read your paper. I'm sure you go through in detail about most people assume that when it says the legislature, if it's about writing the laws, it's using the ordinary legislative process, which would include gubernatorial veto. But I think there's at least an open argument. I don't know if it's a question, at least an open argument about whether if the legislature decides to arrogate to itself the power to choose electors, they don't need the governor. I don't know if there's any history on that. So it's obviously, it's an important topic. Maybe my major observation / question is whether you think it's either for the politics of the Supreme Court or because of the differing nature of the decision. It's a national, it's a 50 state plus territory election for president. It's obviously, of course, national elections for Congress, but I think it breaks out differently. Whether or not there's any argument that for the court to take a slightly different approach on the Article 1 issues versus the Article 2 issues. I don't have to answer that now, but it's something to think about as you go forward.
Yeah, I will say I do think that there's some basis to make that distinction. I'm kind of agnostic about it. Just at bottom, there are some of the big ISLD questions, right? Like, can the state constitution limit partisan gerrymandering of congressional districts? I'm kind of taking a pass on in this paper, in part because other people are doing a lot of work, including a lot of historical work on it, but also because in some sense, I don't think for my purposes, I can assume that there are those that maybe the state constitution can't do that, but if the legislature wants to assert its full notional independence, it needs to say so.
Thank you.
Okay, if there are no other burning questions or last thoughts from the panel, please join me in thanking these wonderful panelists for their paper and presentations, and thank you all for the discussion.
Thank you.
Thank you so much.
Thanks very much. Really great.